this video, we're going to talk about dismissing a disabled employee. I know, that's crazy. And there's lots of intricacies to this and lots of rules around that. We're going to learn all about it. That's coming up now. Hi there, I'm Andrea Adams. I'm the host of the HR Hub. I used to be HR Shop Talk, but other than the name, not a lot has changed. I'm still talking to smart people about all things HR. You can also listen to me on a podcast. Today, my guest is Dylan Snowdon. Dylan is a lawyer here in Calgary with Carbert Waite. He helps employers deal with these super tricky issues. He is also a member of the faculty at the University of Calgary, where he teaches employment law. So he knows a thing or two. Hi, Dylan. How are you?
Hi, Andrea. Thanks very much for having me.
Well, thank you for coming on. It's a bit of an inflammatory title, like we all know that this is a very difficult thing to do. And usually we don't start at the place of dismissing a disabled employee. However, let's just ask the question, can an employer dismiss a disabled employee in Canada?
Yeah, I think it's a funny place to start, but often this is the starting point for phone calls I get.
Okay.
And the answer is yes, there are absolutely situations where terminating an employee with a disability is appropriate and legal. But in most situations, significant effort has to be made in order to accommodate the disability first. So we're required to seek to accommodate that disability before the employment can be ended. There are a few concepts that we can get into more detail about, but essentially, if an employment contract is being terminated for reasons completely separate from the disability, then the termination can be lawful. So I'm thinking of situations like if an entire business or division is being shut down and all the employees are being let go, something like that, where it's definitely separated. Another situation would be where the employment contract has become frustrated. And frustration of contract to the lawyer doesn't mean that the people involved have become frustrated. It means that through no fault of either party, the contract has become impossible to perform.
Can I interrupt you?
Yeah, absolutely.
Interrupt you there for a second? Is the reason for frustration have anything to do with the disability?
Not always.
Okay.
But I think from a statistical perspective, probably most often.
Okay.
So one way that an employment contract can be frustrated, so it cannot be performed through no fault of either party, would be if someone's work permit expired. So you have someone who legally can't work in Canada anymore. Well, that's neither person's fault, but the employment contract can't be performed legally, so it just ends. So this person hasn't been fired, they haven't resigned, the contract has become frustrated, so it's just over. Often what happens, though, where frustration arises is where we have a disability situation. If an employee becomes medically unable to work and the restriction is permanent, then we're looking at a situation that could also be frustration of contract. Every situation has to be looked at individually, but in some cases, employment can be properly ended because of a disability. Usually that means that the disability is going to permanently restrict this person from being able to attend the workplace.
Okay, so in the instance of someone who's on long-term disability permanently, the contract is frustrated?
It can be. There isn't an absolute answer because it really depends on the circumstances. We need to look at who is the employer, what are the employer's abilities to continue an extended leave of absence, and even part of it is, did the parties to the contract consider an extended absence when they entered into the contract? Which often they did, right? The employer is providing long-term disability coverage, so it is something that the parties have considered. All of those weigh into, is this situation one where the contract is truly frustrated or not? And the bigger the employer, the greater the resources of the employer, very likely the more difficult it will be to assert that frustration of contract has occurred. Whereas you've got the two-person shop as the employer, it's more likely that a long-term or permanent disability is going to amount to frustration in an employer of much lesser resources.
You know what? It's already clear we could talk about this for, I mean, you've got a whole career at least partially based on this. So we could talk about this so long. I will try and hold back my questions. But the next one here, just go through the legal protections for employees in Canada who have a disability to protect themselves against dismissal.
Yeah. So the basic part there is human rights law. So human rights laws set out the primary protections, but there are also employment contract and other legislative requirements. So that's employment standards, workers' compensation. And so those things ensure that employees are treated properly regardless of disability. So I know I said a lot there. It is a complex area, but the foundation really is that human rights law and the requirement for employers to provide accommodation for disability up to the point of undue hardship. And so probably the best protection for an employee with a disability who's concerned about their employment being terminated is to maintain communication with their employer about their status and whether there have been any changes to their condition. So many employees on long-term disability will provide their medical information to their insurer. This is my status. Can I return to work? Yes or no? Is there some capacity I have to work? Yes or no? Ultimately, what I see leading towards a dismissal is the employee sort of losing contact with the employer. Employees might think that the insurance company is reporting back to the employer with all the information they're getting, but that is very unlikely to be the case. And so the best protection is for having an employee to actually also reach out and provide regular contact to an employer. Regular might mean once every 3 or 4 months if it's a very long-term disability that everyone knows it's long-term. The expectation is this is going to be an indefinite period of time, but probably a long, long time. But still having the employee reach out can be really useful for protecting the employee's interests.
Right. If you think about that from the other angle, and let's say you've got an employer that is just frustrated and they're thinking, I want to dismiss this employee. They haven't been at work in 2 years. And what is the onus on the employer to reach out to the employee?
I would say sort of gold standard of best practice is that an employer should also be thinking about reaching out to the employee at least every 3 months, even if it's just to say, hi, we're just reaching out to double check with you. Let us know if you have any updates. Give the employee an opportunity to come back with any information. The balancing point, though, is that we don't want to be harassing an employee. If we know that the employee is going to be off work for 2 years, then every 3 months might seem like the employee is being bothered. And so we want to walk that line delicately of reaching out saying, hi, just wanted to let you know that we are thinking of you. This is what's going on at work. If the employee is interested in having that information, sometimes we're dealing with a mental disability that might have to do with stress and anxiety. So maybe telling the employee what's going on at work is the wrong thing to do. It really does depend on the situation. But I think having that analysis, at least on both the employee's part, or if you're looking at it from an employer's perspective, should we reach out? We haven't spoken to this person in a long time. Is there a way for us to do that would still be seen as positive and supportive? And if the determination is no, then I think that's okay. But I think it's important to then diarize it, come back to it another 3 months later. Like, okay, 3 months ago, we decided not to. Has anything changed? Should we think about reaching out again? We want to maintain those relationships. And that's one of the things that does happen is you see an employee who's off for an extended period of time, and the employer sort of gets the attitude of, we haven't seen that person in forever. They're probably never coming back. We should move on. Let's let them go. And that thought process changes quite a bit when it's actually a person, right? So it's, hey, I haven't seen you in a year. Let's go for lunch and catch up. I'd love to hear what's going on with you. And really understanding what's this employee got going on? What's the situation that they're dealing with? Are they just a name on a piece of paper, or is there a relationship there that has value? So I think there is some onus on an employer, certainly to be making inquiries of the employee to find out, has there been any change to the medical situation? I think that at the very least has to be happening annually. In most situations, it can happen more frequently than that. So even if it's just, hey, when you provide updates to your insurance company, if you could copy us on them, that would be useful for us so we know what's going on.
Okay, so how does an employer's duty to accommodate those disabled employees impact their decision to perhaps dismiss?
Well, if the decision to terminate an employee is even partially informed by the employer seeking to avoid its obligations to accommodate a disability, then significant damages can be awarded to the employee. So,
can you say that again? Just say that again, because I think it bears saying twice.
All right. So, if the decision to terminate an employee, if it's even partially, a tiny bit informed by the employer seeking to avoid its obligations to accommodate, significant damages can flow. Those damages can be six figures in some jurisdictions. That would be very rare here in Alberta, but we're seeing jurisdictions across Canada move those potential liability numbers up. So it can be expensive, even if it's just 5% of the reason. It's, oh, well, we have a bunch of reasons to let this person go. One of them is it's inconvenient to be accommodating this disability. Like, oh, well, then now it's a discriminatory termination. So employers managing a disability that requires accommodation need to examine all of the accommodation options. They need to go to meaningful lengths before deciding that accommodation can't work. So in my experience, I find asking an employer, why is this employee being considered for termination? And really forcing the employer to clearly articulate that answer, that often leads to a discussion about whether a disability is a factor in the decision at all. You know, would you be considering this person for a dismissal if they hadn't requested accommodation or taken a leave of absence or disclosed a disability? And if the answer is, well, no, we probably wouldn't. Okay, then what you're considering is a discriminatory termination. And that's problematic. I mean, from a best practices perspective, obviously, but from a potential liability management perspective as well. So I guess in short, the duty to accommodate has to be examined in any situation that an employee with a disability is being considered for termination of employment.
So if I can recap what I think I heard you say, that if the disability factors into the decision to terminate in any way, then you have to accommodate up to the point of undue hardship. Is that accurate?
Dismissing a disabled employee always depends on the details of the circumstance that we're dealing with. We look at things on an individual basis. But undue hardship is the point at which we no longer, as an employer, are required to accommodate a disability. So hardship is absolutely acceptable. So if it's hard for an employer to accommodate, that's okay. That's part of the obligation on the employer. It's like, oh, you're experiencing hardship to provide this accommodation. Yep, that's part of the legal obligation here. The mark is undue hardship, which means too much hardship. And what is too much really depends on the circumstances. Again, is this a giant multinational billion-dollar corporation with a lot of resources, or is this a much smaller organization? And those sort of the ability to accommodate and the ability to weather some hardship is going to change the line of what even is hardship and what is undue hardship. The line is not impossibility, though. So where we've got, okay, it's impossible to perform it. Okay, you don't have to do the impossible. Hardship is here. Okay, well, you do have to do that and everything below it. And undue hardship is somewhere in between them. And it really does depend. Is it a financial cost? Is it an administrative impact? Is it some form of impact on the business outside of financial? There are many different factors that can weigh in and say, okay, this hardship that we would have to go through to accommodate this is too much.
What about the employee's duty to accommodate? How is that relevant to this situation?
Yeah, so employees are required to participate in the accommodation process. They're not entitled to their preferred accommodation if another accommodation option meets their needs and is better for the employer. So if an employee refuses to participate appropriately in the accommodation process, that can lead to a decision that the employment will end. So effectively, we get to a point of undue hardship by reason of an employee's refusal to participate. But an employee not participating correctly, so by refusing to provide information or refusing an appropriate accommodation option, they should always be given a warning so that a refusal to participate could lead to a termination of employment. So basically, we give them an opportunity to remedy or repair the situation. So it's not one where we come forward and say, oh, you've broken your leg and you're not able to do your normal shelf stocking duties. Well, we have a back office job for you. Well, I don't think I would like working in the back office. Oh, haha, now we are firing you. No, that's not how it works. We're going to need to take some steps before we really conclude that this employee has refused to participate. So basically letting them know, here's how it works. This is our obligation. This is what we have to do. Here's your obligation. Here's what you have to do. I mean, maybe there is a good reason for you to refuse to do a desk job with your broken leg for a little while, but it's not clear what that reason is. So let's open those lines of communication before we make any absolute decisions.
I want to ask how hard the employer has to try to make sure the employee understands their duty to accommodate.
I think more than a minimal effort needs to be made.
Okay. Yeah.
So, I mean, we can't control what someone understands, and some people will not behave rationally, and often people act based on misinformation. If we make some efforts to correct the information that someone's basing their decision on, right? You've got someone that makes an assertion of, I have these rights, but their assertion is maybe ill-informed.
Yeah.
I think the answer back is, well, actually, our understanding is different, that this is what your rights are. Here's some resources that you can go to where you might be able to get superior information than what you're getting your information from now. So, for example, where you've got people who are informed by social media of what they should or shouldn't do, or what their rights are or are not.
Right.
In general, I find social media not to be a reliable source of information. And so when you've got employees that are relying on information they may be getting from social media or incorrect information from friends or family, then sort of giving them an opportunity to recalibrate and reset and reconsider, I think is necessary before you can make that declaration of, no, this person really is refusing to participate reasonably in this process.
So let's talk about the steps an employer should take before they dismiss a disabled employee in Canada.
The first question I think always needs to be, like I mentioned before, why is this employee being considered for termination? If it's not an entire business or division shutdown, then I'm going to be asking follow-up questions. Why not someone else? How did this particular person get identified as possibly being let go? Unless there's a clear answer that is totally disconnected from the disability or the accommodation process, then we have to do a closer examination of the accommodation process to see what the employee's needs are and what the employer can provide. So obviously there are other issues that can come up, like seniority in a unionized setting, but just focusing on the human rights side, employers always need to be alert to discrimination issues. Another question I asked early on is, what will the impact of a termination be on this person, just generally? And then specifically, what will the impact of the termination be on this person's insurance coverage? If there are short and long-term disability benefits provided under a group policy, then a termination of employment will likely end that coverage. So an employer can end up taking on potential liability. Well, what if there's a recurrence of the disability? So they were on a disability leave and now they're coming back from it, or they're still on a leave. Is there going to be an impact to the benefits they can receive or the insurance coverage they're going to have? If that's not a factor considered by an employer before a termination of employment, it can come as quite a shock to find out that they owe both severance pay and a couple $100,000 in lost disability benefits.
Something you said there made me think, I mean, somehow the duty to accommodate relates to disability leave.
At a very fundamental level, all employment is contractual. So we're always talking about what is the contractual relationship between these parties. If someone's employment contract says that they will receive short and long-term disability coverage, and they have a disability that may require them to make a claim under that coverage, ending their employment and ending their disability coverage could end up being a breach of contract. So beyond being discriminatory from a human rights perspective, it can also be a breach of an employment contract resulting in losses of money that would otherwise have been paid under a disability insurance benefit, which the employer can then become responsible for.
So they have a disabled employee who isn't coming back to work. What's that attitude that's going to keep them out of trouble?
In my experience, the best attitude is one of compassion. I think employers who, not corporate entities, but individual people who actually have personal experience in some type of disability, whether it's a physical or a mental disability, are in a much better place to understand where this employee is coming from, why they might be making the request they're making. And I think that ability to be empathetic and compassionate really leads people to making good choices. Bad choices are often ones that are made without considering other people and are made quickly and without thought. So we see bad decisions often being ones that are just reactionary. Oh, that person's on a leave of absence. Okay, I'll hire a replacement. And they go off and hire a replacement, as opposed to thinking, oh, that person's on a leave of absence. We're not sure how long it's going to be. I need to hire a temporary replacement. I'm hiring someone for an unknown period of time, but I'm going to structure a different contract for them and let them know this is a disability leave coverage. It's so common for maternity and parental leave. Right, this is a maternity and parental leave coverage, and people just understand that. It's so much less used is the disability leave coverage, is to tell someone that is your purpose. You're coming in for an unknown period of time. It might be 3 months, it might be 6. Who knows? It could become a permanent position, depending on what happens with our person who is left. But structuring the replacement employee so that they know what their role is puts an employer in a much better situation for being able to manage flexibly.
Okay, so I know this is scratching the surface and there's just so much more to learn and so much nuance to this. If somebody out there wants to learn more, what do you suggest?
Yeah, I mean, the federal and provincial human rights commissions and tribunals have websites with Q&As that are a really great starting point for looking at each party's obligations in managing a disability.
Yeah.
Beyond that, I think talking a situation through with a human resources professional and employment lawyers is usually the best, because each situation is unique. Having someone experienced on board is really helpful.
Thanks, Dylan. I know through my own practice just how complicated this can be, but I really appreciated the advice around being compassionate. In any case, that is the end of this episode. Thanks for watching out there. We'll see you next time when I talk with another insightful guest.